Sean todas y todos bienvenidos. Vamos a comenzar la segunda edición del Foro Internacional La Innovación en la Justicia, un esfuerzo conjunto entre México Evalúa y la Fundación Friedrich Naumann para la Libertad. A lo largo de 3 días, estaremos dialogando sobre los nuevos retos que presentan los sistemas de justicia en el mundo y las soluciones para resolverlos. Contaremos con la participación de más de 80 expertas y expertos internacionales en diversas mesas de diálogo, con un nutrido programa donde habrá conversaciones, debate y reflexiones sobre la innovación en la justicia a través de 3 ejes temáticos: mejora y transformación, impacto y alcance, y relevancia y trascendencia. Empezaremos el evento con la proyección de un video corto de bienvenida. Corre video.
El Foro Internacional de Innovación en la Justicia nació en un contexto mundial de incertidumbre debido a la pandemia por el COVID-19. Su primera edición en 2020 fue un espacio de diálogo en el que más de 80 expertos de diferentes países expusieron y debatieron sobre nuevas y mejores formas de mejorar la efectividad de los sistemas de justicia, alcanzar objetivos públicos, mejorar el acceso a los derechos, facilitar la resolución de conflictos y promover la construcción de paz sostenible en México y el mundo. Más de 1,000 personas formaron parte del diálogo y de la creación de nuevas ideas. Además, sembramos la semilla para la creación de una comunidad de personas expertas en innovación de la justicia. Esta es la segunda edición Foro Internacional de Innovación en la Justicia. En un escenario pospandémico en el que las fallas y ventanas de oportunidad en la justicia se han evidenciado, la ciudadanía requiere de procesos más accesibles, inclusivos, transversales y efectivos para una mejor justicia. Por eso, México Evalúa y la Fundación Friedrich Naumann presentan la segunda edición del Foro Internacional de Innovación en la Justicia, en el que más de 80 expertos dialogarán sobre cómo avanzar hacia un modelo digital que utilice las nuevas tecnologías para facilitar el acceso a la justicia y fortalecer los sistemas de justicia penal ante las condiciones de un mundo post-crisis global. La premisa de la que parte esta edición es que la justicia debe evolucionar de manera urgente, transformarse y adaptarse a las nuevas formas y mecanismos de justicia,
the need of its adaptation to the new ways of justice, which are not always judicial, with a focus on human rights, a perspective of gender which is sustainable and open. We'll have 3 themes: enhancement, transformation, impact and scope, relevance and transcendence, which translate into 20 dialogue tables in a post-pandemic context, access to justice to bridge gaps and inequalities and innovations and its relation to human rights. We acknowledge your engagement with the technological innovation for justice to be more expedite. Welcome.
Ahora tendremos la inauguración formal del
Now we will have the formal opening and inauguration, and for this we have Edna Jaime, Director General of Mexico Evalúa, Siegfried Herzog, Regional Director for Latin America and the Caribbean of the Friedrich Naumann Foundation for Freedom, Constance Carrasco, Head of the Unit for the Consolidation of the New Criminal Justice System of the Federal Judiciary, and Alvaro Herrero, representative of the Network for Open Justice. We give the floor to Edna Jaime to start with this opening. Welcome to this second International Forum on Justice Innovation organized by Mexico Evalúa. At Mexico Evalúa, we are convinced that discussions around social demands and the services provided by the state and the public policies to meet needs and to guarantee rights cannot be apart from technological advance, and the best way to incorporate them is to improve the response by government. That is why we are trying for the second year to promote this space in which experts from all around the world will be focusing on justice subjects. What justice innovation means, what technologies can facilitate a better administration of justice, or even more importantly, how can justice be closer to people, and how can we guarantee access to it? These discussions cannot remain at an only judicial setting or logistical setting. Technological progress of the last 20, 30 years that in terms of people is a lot, but in social times are nothing, are showing a very important change in trends. In the past, in the 20th century, which seems so far now, Justice Alternative was missing information, or its information was impartial, coastal, and later-day access to information is different. But in the past, the problem to solve many matters was the lack of techniques and technologies that were being developed at such speed that will not allow for its further dissemination and their adoption. Today's problem is that technologies are developing so fast that the selection of the appropriate ones, of the valid ones, is overwhelming, which is the one that is starting to become obsolete. Only in the last decade or a decade and a half, dissemination and rapid adoption of smartphones has changed life and the dynamic of our relationships in ways that we have not finished to understand, nor to understand in their impact dimension. We are in a new era. And that is why, as a society, but above all, as decision makers, as activists, as stakeholders and analysts, we must maintain a rhythm and the pace, and we have to understand the impact of these advances, aiming at designing best strategies for their incorporation into justice. It's a rapid evolution and rising entails a transformation of management and administration processes of justice institutions, and it has simplified the process, but we have to get to the core of every institutional transformation, which is to provide timely, effective responses to social demands. That is, we have to multiply the impact of the government acting and to improve the citizens' quality of life. This is a driver to Mexico Evalúa. That's our main goal. This forum's goals are those: how to use technology, how to innovate, and what to innovate on as to improve justice quality, as to streamline and guarantee right access to the citizens to timely and effective justice. We have to associate justice to technology, and this is an important highlight of this forum. Innovating means question paradigms, propose innovative solutions to current problems. This means of engineering in the conception of justice. We have to reconsider the goals of society's design and dispute resolution. This combination of themes, technological innovation, our digital world, which is expediting ever more, innovation that besides incorporating a technological aspect, incorporate the challenge of a status quo. This is what is calling us for these 3 days of innovation in this forum. We'll have several tables in which we will be discussing innovation, its implications, its relevance, and adoption strategies. For me, I am very excited about this forum, and I have some expectations about it, because I think that if we manage to transform justice in Mexico, we will manage to transform the country. That is why we have brought 85 experts together from 32 countries of 3 continents, from the academia, the private sector, the civil society, and public institutions, to add voices, visions that echo that make us challenge what we know and to foresee an inclusive justice project, which is innovative. This is a dialogue in which we will have the echo of these learnings and perspectives, and we will be listening to organizations, governments, researchers, because I think, and I am deeply convinced that the big topics are solved in these schemes in which several stakeholders take part. In the end, we are aiming at having information that guides us the construction of the justice innovation agenda. I will mention some of the subjects that we will be covering: the use of artificial intelligence as a support to the justice system, which entails a risk, or is this an area of opportunity? And this is not just a Mexican question, this is something being questioned around the world: the impact and the role of COVID-19, of the COVID-19 pandemic, and the impact it is having on technological innovation, creativity, and everything that we need to develop face to this impact and need. Big data as a tool for predictive justice. Also, gender equality, we want our focus to be on the research about crimes of this type, which are the means we have to guarantee women's security, which are the challenges of democratic, accessible justice for everyone. What do we have faced to in generalized inequality and the current challenges in terms of inclusion? The internet, the role of internet and technology to guarantee rapid access, and community justice role for the pacification of communities, and the results that I have found in the places where this has been applied: restorative justice as an alternative to a criminal punishing system, climate justice, impact of social media on justice, and how society can condition its exercise. Those are some of the topics that we want to cover, and we believe that this go hand in hand with this country's agenda, but also what is being discussed internationally. I hope that we could contribute to discussions at a broader level in terms of what concerns our country. This has already been mentioned in the video and also the Master of Ceremonies. We have to work on the main three topics in a post-pandemic world: justice in a post-pandemic world, human rights and innovation. Of course, a serious discussion about the justice evolution, innovation, and technologies must address climate justice, peace building, and impunity topics. Since we did not want to have only theoretical discussions, which are very valuable, of course, we held the innovation workshop with over 80 people selected who throughout 3 days analyzed justice problems and then design and build practical solutions that we will be presenting in this forum. And we are aiming at building a discussion innovation space in which we can be together, the academia, civil society, decision makers, activists from different countries, so we can deepen in the topics that require urgent attention. I want to tell you that all of this is very ambitious and has a very high goals, and this would not have been possible without the support of the Friedrich Naumann Foundation, and we thank them for their support, their trust, and their conviction. And that's everything that I want to highlight here. At the foundation, they are completely convinced that this is the future, and it's here where we convene. Thank you. Now, I want to give the floor first to Siegfried Herzog, Director General of Projects for Latin America and the Caribbean of the Friedrich Hayman Foundation. Every time we have something important, I want to thank you for your support, and I want to tell you that our shared conviction is going to be very fruitful. The floor is yours. Thank you very much, Edna, and also thank you for the cooperation throughout these years. Trust, mutual trust, cooperation, and mutual engagement to improve justice systems and the rule of law. On behalf of the Friedrich Hayman Foundation, welcome to the Second International Forum on Justice Innovation. In the 21st century, we have witnessed exponential technological advances, but also ever more complex challenges. On the one hand, technology and internet facilitated connection between different countries, and they approached us to different people. On the other hand, the pandemic paralyzed the whole world, and this is a context that obliges us to reflect upon how we can use technology for dispute resolution. This is an opportunity to innovate and to think out of the box. In this sense, in terms of justice, it is necessary to wonder how we can incorporate technology to a justice administration. Can technology or innovation facilitate and make dispute resolution transparent? Is it possible for justice to be closer to citizens and be based on citizens? Technology and innovation are a key piece and will continue to play a crucial role if we take some time and stop and think about how we want the justice system to look like in the future. That's why I am honored that the second forum program is offering fresh perspectives of experts in best practices such as artificial intelligence in criminal justice systems, technological innovations in criminal justice, predictive justice throughout the use of big data, innovations that challenge human rights, technology and internet for rapid justice, and finally social media for justice administration. Besides thinking about these topics and the role of technology, there is something that everyone here and has in common, and that's the fight for justice, the look for truth, and the aim for the victims to find their voice being heard. Access to justice is an obligation by the government, and its guidelines must be based on human rights. At the Friedrich Hayman Foundation for Freedom, we think that it's difficult to be free when there is no justice, no security. That is why we defend and promote a rule of law based on independent institutions. A participative democracy cannot thrive without institutions guaranteeing the protection of human rights of every individual and of institutions that solve disputes in a pacific and just way. Only institutions can make sure that public powers act within the legal frameworks established by a constitution. At the foundation, we speak about institutions because they are the ones that independently can answer and protect from abuse of power and bring to justice the responsible people. In our experience of over 60 years in several countries, we have confirmed that if we want justice for everyone, we have to promote the rule of law. Today, we are being offered this opportunity to take one step further in the improvement of justice and the creation of new tools, such as technology and digitalization. These technologies and give us the opportunity to have a further transparency and to limit discretional powers in decision-making. This forum gives us the opportunity to imagine a more transparent, expedite, and resolutive justice, not just for the system operators, but for all of the individuals. This is a space for the promotion of legal education. Improvement in justice requires that every one of us approaches justice, understands justice and its processes, so we can be aware of how we can defend our rights and how we can fight against corruption and power abuse. Maybe not all of the practices here will be applicable, but all of them will provide us with ideas or starting points to think about innovation in justice. I thank Mexico Evalua and the team of the Friedrich Schaumann Foundation in Mexico for making this forum a possibility. And finally, I wish you fruitful conversations and inspirational discussions. Thank you very much. Thank you very much, Siegfried. Now I want to give the floor to Judge Constance Carrasco. And Ms. Judge, you are the head for the consolidation of the neo-criminal justice system of the federal judiciary. And I know that you are deeply convinced that we have a need to innovate and change justice. And it would be a pleasure for me to listen to your opening remarks in this forum. Thank you very much. And good morning, everyone. Thank you very much for the opportunity given by Mexico Evalua and the Friedrich Schaumann evaluation. I want to thank Edna Jaime, especially and all of her team, for their invitation. I greet respectfully the panel. Citizen participation in the government and open discussion on public interest matters are a substantive part of the democratic country's agenda. Level and quality of the scrutiny that is conducted about the institutional acting in the rule of law is the best indicator, in my view, of an actual accountability. Without scrutiny and without its quality, there is no accountability, especially when we speak about courts or tribunals and that are responsible for protecting fundamental rights. We need dialogue on constitutionalism, in which constitutional matters, in this case, justice as a right, because of its transcendence, must be solved through extended conversations persistent in time, and have to involve different areas of power and government as well as the citizens. And this is what we are doing here. There is global consensus, and today we are here because of the need to improve experiences at the jurisdictional agencies, as well as the general perception of trust in justice operators. The COVID-19 pandemic put the world in a health crisis without precedent that obliged the governments to take extraordinary measures to mitigate the disease effects and to prevent its dissemination. The health emergency demanded in all of the geographies to rethink the different scenarios, and also the service provided by courts by a measure of progressivity and respect of human rights, working schemes guaranteeing the exercise of the effective protection of human rights. The federal judiciary was no exception to that, and this period has allowed us to realize of new challenges, lack of appropriate infrastructure, lack of connectivity. Well, there are still several regions in the country where we do not have the internet and even less access to free internet, intermittent failures, which makes daily work more difficult. For instance, video conference hearings, electronic notifications, online trials, and budget constraints. In the justice setting, in the jury trial justice system, we needed a public policy to balance the different health measures to guarantee right to life and the life of all of the justice system operators, so we can continue the operations and functioning of the criminal justice system. And this measure considered a guarantee of judicial protection through real-time video conference at the 43 different justice centers of the country for every urgent or priority matters, until we covered several actings and proceedings that are to be solved at first and second instance courts. And from every part of the country, people can connect through different options and devices, computers, laptops, tablets, mobile phones, and through software tools. This measure considered the principles of Article 20 of the Constitution for the jury trial justice system. To preserve these principles through video conferences has made a good job that we have to acknowledge in terms of due process. The challenge is to ensure the acknowledgement of the linguistic components, voice, pace, modulation of the parts witness, pauses, body language, side, grimaces, and gestures. And this has been exponential because of video conferences. And in this order, we can acknowledge that the real-time video conference scheme is a standardized balance that makes compatible the health measures established by the health authorities to the protection of human rights and due process. And this required a coordination exercise within the federal judiciary as to coordinate the work of 170 control judges and more of 30 first courts. We have had over 50,000 video conference hearings in real time at the federal judiciary in the 43 centers of justice. Finally, in the jury trial criminal justice system developed by the federal judiciary, made available to society the consultation of the public versions of different sentences with a search, advanced search engine with the different filters. Today, this search engine offers 20,166 sentences of jury trials, sentences decided by the judges, sentences that at the beginning of this year were not available for the consultation to the society. Today, this network allows us to disseminate this to everyone who has access to internet through friendly consultation media. I would like to take this opportunity to highlight that the system for the registration of sentences that was established by the federal judiciary considers data analytics, which allows us to develop public policies that allows us to consolidate the new criminal justice system, having the society as the main beneficiary of this public service. The pandemic allowed us to see that we can benefit of these opportunities provided by technology to change the way in which courts work. We can't renounce to its evolution. Thank you very much. Thank you, Judge Carrasco. It's very important to hear everything that the federal judiciary in this context did, very important advances, and I think that they have to be known. I think that we have many things to do, but also many decisions and actions that were made and taken at the federal courts. And I just want to say in a parenthesis that we are working on this. We have made some work by the federal and state courts during the pandemic, and how innovation with the technological progress, it's also something that is happening in our country. It's important for this to be documented and to be shared. Thank you very much, Judge Carrasco. And now I will give the floor to Alvaro Herrera, a representative of the Network for Open Justice. Alvaro, we're very interested in getting to know what you're doing there. What are you doing there? And what are the members of the network doing? The floor is yours. Thank you very much for having accepted this invitation to take part in this forum. The floor is yours. Thank you very much, Edna. Thank you for the honor to take part in this space that I think is amazing and very valuable. From the International Network for Open Justice, we're working throughout the region by promoting reforms that concern innovation, that concern the openness of justice systems, accountability, and also for transparency in a broad and comprehensive sense. In this sense, maybe we're seeing some remarks, and I think that this edition of this forum is more relevant because we are going through a pandemic of specific characteristics that has affected the functioning of the justice systems of the region and has jacked some of its components. But I think that Latin America and the Caribbean were at, provided a good answer, and they implemented systems that guarantee justice administration and to a large extent the protection of human rights, due process, and all of the procedural guarantees that are protected by our constitutions and our international law treaties. In this sense, I think that this is an opportunity to see how can we leverage these advances, these feats in a very few months that had taken years to promote last year. So the need to move forward with the reforms was assumed, and that's the challenge we're seeing throughout the region with regards to the way in which we can consolidate and materialize these reforms and prevent any drawbacks. I think that this is important, and I think we have an important challenge and opportunity that concerns knowledge. And in this process and throughout the last years, there have been advances in technological advances, digital transformation of the state, including the judiciary, and we have new practices evaluations that are already there available, should be there available, so we can share them with all of the stakeholders of the region in the justice field. We have a breach, we have a gap here that consists of devise, the platform, the tools, so we can capture and share and that knowledge. Justice systems, judiciaries that have less resources, and here we have an opportunity to be more efficient in scaled economies, and knowledge management is a key element for the next years. The third point that concerns us is how we can have a revolution of data at the judiciary. We need a technological revolution that allows us to make decisions with empirical data, policies to govern the data that are being produced within this justice systems. And in this way, we can move towards a judicial system that are not only going to produce data, but who are intensive users thereof. And I think that's another important challenge. And the third one, I think that this one is ideal for this, and it's the identification of institutional designs at the judiciary, allowing or facilitating innovation. innovation is an innovative topic in the public sector, not just Latin America, but international. I think that the judiciaries have an opportunity to identify the institutional reforms they need to facilitate innovation, and for it to happen within the judiciary, also actual innovation policies can be designed. In fourth place, I would like to resume what the judge said, the technological innovation, and that's the live motive of this event. But we need to sustain some policies that are rather institutional in nature that have been worked in the region concerning open justice, transparency reforms, open data, citizen participation, accountability that have to go hand in hand with the digital transformation reforms of the judiciary. I think in here we have four main challenges that can inspire us to frame all of these reforms and discussions. And I think that spaces like this one allow all of the stakeholders working in the judicial systems of the region to connect and work together and design an agenda of reforms that allow the region to move forward in such important challenges that justice systems have today. Thank you very much. Thank you very much, Alvaro. Thank you for your work. You are a very active promoter of this linking between organizations and ideas of these groups of different actors that promote innovation. So your participation in this forum is pivotal. Thank you very much for being with us for the inauguration. Now, before giving back the floor to the Master of Ceremonies, is to tell you to continue to follow on our social media this event for all of its panels. I think this is going to be a very rich discussion, and we have to assume this for the innovation to improve access to justice and justice in the country. From Mexico Evalua, that's our goal, and that's why we promoted the continuity of the forum, and we will continue doing so. And I hope that the Friedrich Haumann Foundation will continue to support us in this goal. So at 11:08, I officially declare open this Second International Forum on Justice Innovation. I wish you the best of success to all of the stakeholders, and I hope you will find innovative ideas that will allow us to build a new paradigm that is beneficial for everyone, for those operating justice and for users of justice. We want access to justice to be guaranteed for everyone. Thank you very much. Those who were with us today at this inauguration, thank you to all of the Mexico Evaluation.
These are two large areas, and I'm going to give you an example. One of the data was already mentioned, which is related to a whole data analysis area. This is something that is going to give us something real. The standardization or homologation of data is also one of the greatest issues. And on the other hand, we have something that is not new, which are the expert systems. And these are basically systems that where we give the knowledge and we take this knowledge from human experts. I take a medical expert and I start asking them a lot of things with a specific part. I organize that and I feed that to a system in such a way that the system may use this knowledge to make decisions. And something very important that was mentioned by my colleagues, these are also support system for decision makers. And here I would like to mention something, and I would like to do a parenthesis on what they have mentioned of transparency, data privacy, and the ethical principles that were mentioned. I need to say that in the last few years, from the last 5 years until now, there has been a really great effort of the international community to regulate artificial intelligence, to generate guidelines, and to establish ethical principles that allow us to validate and guarantee that artificial intelligence tools don't do inappropriate things. There are very known cases that in order to identify a person, there are a lot of biases that identify that person as someone who they are not. And this is not a problem of artificial intelligence. Sarah mentioned it. One of the problems is quality of data. If I am going to train an artificial intelligence system to identify that they are a man or a woman, and it turns out that I trained them with 10,000 images of women and only 100 images of men, I'm sure that they are going to be wrong with men and not so much with women. So this data must be balanced.
There are several efforts here in the community. We have a series of principles. Even we had some principles I don't remember last year. And we have to have this AI systems apply to justice. They have to be transparent. They have to be equal, egalitarian. They have to be responsible. What they were saying, if an IA system makes a decision, what's the problem? The system or the person making the decision based on IA? On the IA algorithm. There are many efforts being done already. An analysis we even conducted about 2 months ago, there were about 80 groups of ethical principles that have to govern the IA system. So there is a lot of work to do. And yes, this has already been mentioned. AI has been sold, as you can see this in sci-fi, in films that they're going to be governing us and so on and so forth. Let's not fear IA. IA has a lot of potential to support society. We have to fear not using it. If a company does not use it, it's staying behind because its competitors are already using it. If a university is not using IA to support the educational process of its students, careful there because this is already being done elsewhere. So I'm going to stop here for the next block. Thank you. Thank you very much, Felix. This is an amazing remark. This is like the fear when we were kind of learning to ride a bike. We have to keep all proportion, of course, but it's unavoidable to prevent all false, with false positives, which are the fear when we speak about these topics. But there won't be any way to improve this if we do not continue to improve the use of these platforms. When the topic is good and when those who are exposing this, as is your case, well, this goes very fast. Before saying goodbye and thanking our public to come to discuss about this topic with you, I would like to ask you, you have shared with us some of the problems, some of the challenges, and some of the topics on which we have to focus our attention in terms of IA, especially in terms of use by the government and in criminal justice systems. And also when we speak about humanizing these technologies, as Antonella observed during her presentation, and the relevance in terms of gender topics. We want these platforms to be fair, assertive, and they have to allow, and you have already reassured us that it's not the last decision. And the relevance highlighted by Sarah, which data and how are we going to be feeding these data from the government to this type of system? So in so much as we will have data, they're going to be actual and they can have some scope, and then we can be certain about the use of these technologies. Felix, you have shared with us about the relevance of the working methodologies such as clustering, the relevance of uploading a lot of data, look for specific cases. But then we can go to some specificity. So within this world of data, we won't have these false positives and in an important amount. And also, you helped us lose fear of the use of an algorithm, which is not in itself a mean and evil word. It's part of a system that we're going to be educating, and this has been really fascinating. I would like to propose to you for this last round for closure to share, of course, the positive aspects. What are you excited about in terms of technologies for justice systems? Where are the immediate and the long-term benefits that you used to? What are you excited about your work in terms of IA? Because given the challenges that we have discussed, and we will be able to get to nirvana, in that sense, so to speak. Antonella, the floor is yours. Well, I think that the possibility to streamline human rights is essential. The bureaucracy we have seen in the judiciary, the amount of cases, sometimes we lose sight that on the other side we have a person that is affected in their human rights, and sometimes family and all of their setting. We have to see beyond and how we can use a tool. So the human rights of people are a pivotal element. So we can take and so which are not in essence when we work within the judiciary, and this will manage to give a better answer to people by the judicial institutions. And also this can be used to prevent any state irresponsibilities. And I think that this has a huge potential because in Argentina, we have such cases because of very informal matters. It's not material matters even. And this is going to decide whether a person will be imprisoned or not. But these are there to help people in that decision making, and this can be a very important ally in terms of state accountability and for the protection of human rights. Thank you very much, Antonella Strongini, Academic Director of IA of the School of Law of the University of Buenos Aires, and she has honored us with her presence here. Sarah Hirsch, Intelligence Analyst and Forensic Analyst at Kroll, Mexico. Go ahead. Thank you. I will say again that I am very excited about the opportunities for bureaucrats, which had an important workload because they have to process a lot of information, and these tools, when used as tools with a good quality of data, they can help them to conduct their work in a better way, in an easier way, and in a more complete way. The government services of the justice system can reach a greater number of people and in a more accurate way. And I am also excited about the possibilities to understand what is happening in the security setting of the country. For instance, we can make studies, or we can take studies from other countries that, for instance, in my case, in a fully independent work, I analyzed a database which was classifying the level of violence of some insurgent groups in the Middle East, according to several characteristics of the organization. This was sexual violence, I have to precise, and based on this, I used IA tools to make a model that later on can be applied to the Mexican context, to have an idea about what we could expect from which groups, what is going to happen, what can exist in this territory. There is a greater openness to know what's happening, to know further what's happening in our reality. Thank you very much, Sarah. Felix, please, your final thoughts. Once again, thank you for your participation and for the opportunity to get to know your knowledge or experience. And he is the director of the Mexican Society of Artificial Intelligence. Without a doubt, IA has tools that are going to be used as support, from very simple things, relatively simple, so to speak, in terms of justice, all the way up to very complex ones. A very simple one would concern those known as chat bots, which are those virtual assistants with which we start to interact as a person. And depending on what you will reply based on what this assistant is giving you, well, then you will be moved to one office or the other, and all the way up to very complicated cases like the one mentioned by Sarah. We have a lot of data. We're using data mining and advanced techniques for data analysis to identify costs. And so these behavior modern patterns can be extrapolated to other settings, and all the way up to the most complicated ones, which are technically spoken as vision by computer, in which through drones, cameras, we can take things. And what Antonella was saying, we can identify whether the person who is being sentenced is actually the one who did things. And artificial intelligence can identify this, whether it's Felix Castro, the one you are presenting right now, based on the picture that was taken. In Mexico, we have a case of the death of of a former president, and we know that it was not the same person who was, tried. So for this type of things, artificial intelligence could also be helpful, of course, in combination with biometric exam and things like. But something very important that I would not like to, with which I would like to close my participation without, without skipping it, is the opportunity we have had. I mean, those of us who have the honor to work on artificial intelligence, and we all are governed by a principle called AI for good. Artificial intelligence for well-being. I don't know, someone who is not developing there are things for our beneficial goals, and that's they are the relevance of our regulations we were speaking about. Of course, I don't know that there are negative goals here, but this could be the foundation to tackle those problems, and it has happened before in other settings for which benefits of scientific advances are applied, not just for well-being. And this is how we want to close again. And I want to say artificial intelligence is to be used in the benefit of society. And we ask the Mexican Society of the Artificial Intelligence, we are at your disposal, at the disposal of people who work in the justice setting, so we can help them. And of course, we will be happy to help you, and feel free to reach to us. Thank you very much. Felix, thank you very much. And thank you, Mexico Evalúa, for the invitation and the opportunity. So through this second International Forum on Justice and Innovation, we have the opportunity to listen to experts, such experts as we just did. Stay with us, because as you know, this event is going to be held from 16 to 18, the next panels and the next participations. Well, it's going to be clear for you how interesting this is going to be. I'm Emilio Saldana in the teaser, and for me, it's an honor to moderate this panel, to learn from this and to learn from our guests about artificial intelligence and the challenges that the criminals and justice systems have and the benefits that they're going to be leveraging. So thank you very much for having been with us today, and have a great day. See you in the next panel. Thank you.
Recording in progress.
lugar a duda, en el panel previo abordamos temas de vanguardia. La inteligencia artificial es una herramienta más, hay que comprenderla y hay que aprovecharla. Muchas gracias a quienes participaron en este panel: Emilio Saldaña, a Félix Castro, Antonella Stringini y Sara Hirsch. A continuación, tendremos el panel 3, denominado Innovaciones Tecnológicas y sus aplicaciones en la justicia penal a partir de la emergencia sanitaria por COVID-19. Este panel estará moderado por Úrsula Indacochea, directora de programa de la Fundación para el Debido Proceso. Además participará Marco Fandiño Castro, director de estudios y proyectos del Centro de Justicia de las Américas, María Fernanda Rodríguez, Senior Fellow del Centro sobre la Cooperación Internacional de la Universidad de Nueva York en Estados Unidos, y Nora Lucy, coordinadora del área de gobernabilidad democrática del Programa de las Naciones Unidas para el Desarrollo en Argentina. En este panel se abordarán los temas de cambio en la justicia a partir de la pandemia por el COVID-19, las innovaciones tecnológicas en el campo de la justicia penal, implicaciones y beneficios del empleo de nuevas herramientas tecnológicas en un mundo post-COVID-19 y los retos para ello. Le damos la palabra a Úrsula Indacochea.
And activities such as hearings, resulted in a redefinition of what was to be resolved as a priority. Justice systems undertook to address emergencies by using technological innovations, technological tools that in many cases had already been working in an exceptional way. For instance, telematic hearings or the use of virtual mechanisms for the filing of lawsuits. Without a doubt, within this universe of the urgent criminal justice was a protagonist in it to protect personal freedom of the accused and to solve its procedural situation. Placed at the center of discussion the way in which we could continue with these innovations and respect procedural rights, the right to be heard, and guaranteeing the access to justice for victims. So we're going to be discussing about this topic with two expert women and one expert man, because without a doubt, technological innovations have come to stay, and they entail big challenges about which we have to discuss and upon which we have to reflect. So I'm going to start with one first question to our panelists, which who were already presented by our Master of Ceremonies, and it is a common question for all three. What were the main challenges for criminal justice faced to COVID-19, and how did technological innovation contribute to address these challenges to create a better, more effective, and more independent justice system? We're going to start with Marco Fandinho. The floor is yours. Thank you very much, Ursula, for your presentation. It's a pleasure to greet you, Nora Maria Fernanda, to share with you in this panel. I want to thank Cristel Rosales of Mexico Evalua for her invitation to take part in this forum. During these minutes that you are granting me, Ursula, I will try to characterize the three main challenges that we have had in at the Latin American region when incorporating technologies to criminal justice, and I would like to specifically speak about these interoperability and coordination between the different institutions. Number two, I would like to directly speak about the incorporation of technologies in the judicial proceeding filing, and finally how we understand that jury trial could work in a telematic or virtual hearing context. For the first point related to interoperability, what we have seen is that those countries that have kept institutions as responsible for the criminal proceedings that have not been weakened, as the case of Mexico, where once the jury trial was integrated, the institution responsible for implementation's take was not longer functional, while there is a coordinating unit of the criminal process reform by the years of the implementation of the system. Then it became a more bureaucratic institution and a more separated institution in terms of the criminal justice daily work. But those countries with sound institutions of coordination between institutions and allowing to identify problems and to take immediate actions were able to provide a better response. And I would like to add a complexity to this, which concern the fact that the COVID-19 pandemic also created a series of social and political countries in many countries, and most of our countries, especially in the criminal field, this concerned alterations of the public order, demonstration, social crisis, and therefore a new complexity added to the pandemic, which concerned how the criminal system was providing a response to this type of social problems. As INASE has studied together with the University of Chile and the UNDP, we were saying this. First of all, public defender office, which concerned the different offices of the Attorney General, to have access to free justice. On the other hand, we were seeing a prosecutor office which wasn't able to conduct investigations in a due time, and the data that were being shown in the last that was shown in the last 2 years concerning impunity. And also in a third point, we were seeing problems in access for justice to victims, because many of them hadn't been able to receive even an interview. We're speaking about this type of challenges during the pandemic with the social crisis in several countries. And we thought that this entails an important complexity for all of the criminal justice system institutions. In terms of procedures, there were already a series of initiatives that in most countries have been working with the different types of implementation or success. In Chile, for instance, from 2015, we have a law for electronic filing that allows to have a virtual judicial office that allows for the attorneys to file their writings from their offices, and therefore they don't need to appear at the courts. And this is something that, with the different degrees of implementation at the different stages of the procedure, most countries have implemented some of these innovations. As Nora and Maria Fernanda, there are experiences in Argentina in several of its provinces. In the city of Buenos Aires, they already have experience in electronic filing, and quite surely they will be able to illustrate this further, and I mean the innovations in Argentina. But we see that many other countries in the region have also made a progress in these strategies. And to finish the main debate that has been around concerns the limits, and above all the warnings that we have to conduct with regards to the possibility for public hearings and jury trial proceedings can be held through these methods. I think that we have to pay special attention to the different problems that each hearing can have. Several NGOs from Latin America requested for meetings and conduct activities with the Inter-American Commission, in which they made it known that some obstacles were being found in when we needed communications between the accused and the attorney, and also possible cases of torture in which the telematic character of a hearing could create some kind of a difficulty from the point of view of the realization of these situations, and what concerns the generation of protocols, which is a response to that started to be there in some countries at the beginning of the pandemic. There were a few countries that have these protocols, but ever since there are many protocols related to how we can indeed conduct any type of hearings in a telematic way, but of course within a series of conditions, a series of constraints, and a series of aspects that have to be taken into account. And many things have already been said and published, and I hope that in the next blog we will be able to continue our discussion. Thank you very much, Marco. Without a doubt, it's very important to know that the challenges are not just technical in nature or are found in some deficiencies, but also these are challenges in terms of rights. We have to see this from a human rights perspective. Now I will give the floor to Maria Fernanda. Welcome and thank you for being with us today. The floor is yours, Maria Fernanda. Thank you very much. It's a pleasure to be here for the second International Forum on Justice Innovation in Mexico. I want to thank you for the opportunity to take part in this space as Pathfinder offered by Tini Morales, and also the opportunity, the unique opportunity to share with Marco and Nora Lucy. I had a presentation, but if we can't show it, there is no problem. First of all, I wanted to contextualize the work we are conducting at Pathfinder, so I can explain to you from which perspective we are going to be conducting an analysis of such a pivotal topic that we are addressing in this panel. And later on, I would like to briefly speak about justice and the impact from the pandemic and the justice needs of people. And finally, people-focused justice. And from this, I would like to speak about the challenges of innovation in terms of criminal justice. As you know, the SDG 16 is a very innovative goal in the global development agenda, and as such, it represented a huge challenge, and therefore a group of countries became pioneers and developed a series, a roadmap of a peaceful, inclusive society that delimited strategies and plans so we could achieve SDG 16 justice. Without a doubt, it was a priority here, and that's why, since this was one of the SDG 16 three components, a specific working group was established to identify strategies and plans that would allow us to promote equal access to justice. And this working group was led by Argentina, the Kingdom of the Netherlands, and Sierra Leone. And this is a group that, together with international organizations, joined in a process that finished in a publication and a report called Justice for Everyone, together with a series of specific reports on transitional justice, women and girls. This working group defined one first strategy that was pivotal, and which was to bridge the gap, and it was determined that there is a huge gap between what people receive as justice and what they really need. And we were speaking about 1.5 billion people excluded from opportunities, from social, economic, and political opportunities given by justice. Let's say that we are 7.8 billion people in the world. So this number imposed, without a doubt, a moral imperative for us to bridge the gap, and therefore it was necessary to produce evidence in terms of justice access for people. And somehow, so we could do this, we needed to understand how to solve and how to prevent justice problems for people. Now, speaking from where we are coming, I will go to the next one, which is how the pandemic impacted access to justice for people and what the impact was in justice and the justice setting. And for this, we created a series of summaries which were linked to public crisis and the new social contract. Basically, COVID-19 crisis created a triple crisis because of health emergency, the economic crisis, and social impact of the virus. And concomitantly, the justice system acted as Mark and Ursula were saying, well, when here we had constraints for the administration of justice, the lack of the impossibility to appear at court and for the procedures, and so the work of this field was restricted. And number three, because of economic crisis, we have a lack of funding, including the public sector. Therefore, innovations are more difficult to undertake, and the result of this triple crisis that we have to do more with less. And a horrible statement. We have to give more access to justice, and this is only possible if we apply three things: innovation, creativity, and collaboration, which are pivotal in this. So we're going to be speaking now from the point of view of innovation. COVID-19 crisis was an opportunity to streamline justice systems. As we know, the first response of the judiciary was to close its doors to the public in terms of hearings, deadlines, documents in writing, and a series of practices that on the one hand were there to mitigate the propagation of the virus, which were closing the access to justice services to population, and the extension of a pandemic required a rapid adaptive response to the circumstances that will allow to continue the work of the justice system. Therefore, measures by the general attorney offices, the prosecutor offices, and it's important to mention that the technological infrastructure was in most of the cases ready to be used remotely.
It was impossible to use a digital signature to get this information in the digitalized databases and to do the procedures digitally, as well as to do hearings on technology platforms and create the record. So at a certain extent, we had the technology resources necessary to report in a remote way without requiring physical presence. And in the justice systems, we had the resources to move forward in these management cases. And if this didn't happen before, was because of the lack of necessary consensus or the institution decisions or the resistance that the system has when working with innovation. Now, also the use of this technology should allow us to reestablish the work, the functionalities of the justice systems, but they also had to see that the systems were respectful of those cases related to the due process. And that's why we started with the digital signature, the regulation of the different modalities of remote work, which was another challenge for justice for these digital signatures. Also the claim channels that are very important online, the email usage with immediate response, the 0800 also resources and the technological means, the remote access to management operation systems, video conference platforms, the connection between the different systems. And also, as Marcos mentioned, we had to assess the format of hearings through a conference call. And there were a lot of concerns on how the constitutional warranties were going to be kept in a criminal procedure when we were not able to do the trials in person. So as we know, these trials where we need immediacy is something very important for the system. And that's why in general lines, what we tried to solve and how we tried to solve it was by reestablishing very precise ways of how to do it and what were the cases where we could use it and how to guarantee connectivity, participation, or of the lawyers in order to control that there were no coercion on the accused person. And These are great opportunities for the justice systems in order to move forward to the digital management of the case. And there are a lot of challenges, but we will continue to talk about this in the next participation. Thank you very much, Maria Fernanda. Without a question, establishing all these mechanisms is a great challenge, but we can also innovate from communication of the justice systems with the users in order to learn how to use all these mechanisms. Now I'm going to give the floor to Nora Lucy. Thank you very much for being with us, Nora. Welcome. Thank you very much, Ursula. It is a great pleasure for me to share this panel with Marco and Maria Fernanda. I would like to thank Mexico Evalúa for this opportunity of being here. There is not so much that we can add to the great presentations that my colleagues just mentioned. Now I'm going to try to add some comments, some remarks that are more focused on what both Marco and Maria Fernanda mentioned. And this is related to the situation of the adaptability when facing the pandemic. So both in developed and developing countries, and with this issue of the pandemic, and the initial reaction was obviously the closing of courts, and always we left as an exception urgent issues, so criminal cases with accused people, and in case of families as well, the provision of food as well. So in the different jurisdictions, we took into account what was actually urgent. And there are very interesting reports both from the OECD and other institutions where we have seen that they have also needed to react quickly and have these adaptation capabilities. And now regarding technologies, it's not because of the pandemic. We understand that definitely what the pandemic did was highlight the need of leveraging the technologies, the tools that we had for the provision of public systems and services in the justice system. And it also highlighted these gaps for the access of justice that also in terms of digital access were totally visible, not only in the need of the justice sector that we had the technology infrastructure and the ability to provide the service remotely, but also that both victims and in the case of criminal law, the accused, they should also be guaranteed the possibility of participation and the exercise of their own rights. In the case of Argentina and some countries, federal countries, as you know, it is very difficult to do an assessment because what we have seen is that the advancement of the use of digital technologies in justice is very unequal regarding on the area that we are seeing. In general terms, we saw a certain definition that was very severe in the creation of services. And once the protocols that were established on the judges' offices, all the support staff, all the employees in general were not going to the courts. And we also saw a great responsibility for the judges and the courts that have had to continue doing their services. And we need to think that we could see that we move from analog justice to electronic justice by doing these procedures that are not minor, and then to digital justice that implies the total elimination of paperwork, and it's something that we have not reached in all regions. In Argentina, this is a process that we are moving to. And I think that what the pandemic did was make this consensus more agile, the need of getting a consensus so that we could provide these services. Let's think that from the democracy standpoint, the judiciary should not stop the providing of services. And as Marco mentioned, there are also other challenges that come from this emergency situation with moments of violence and other issues that also had an impact in these emergency purchases that people were doing in different states, and also corruption cases. And just to finish up with these first comments, it was a challenge for all countries, and one of the main things that we could see was the response capabilities of the judiciary depended on the digitalization that they had in the moment the pandemic started. In general terms, we may not talk about digital justice that is general, and there are several exceptions. In Argentina, we have been able to systematize a case where a criminal court in an area of Buenos Aires, they continue with the service provision in a regular way. They didn't have an interruption of services. So what we did was to do some research and see what were the previous conditions that that team had so that they were able to provide their services without interruption, especially during the long period of lockdown that we had in Argentina, which, as you know, is maybe one of the longest periods of time that we have had in this pandemic. Maybe in the next participation, we can talk about some of the tools that we understand that were useful, and maybe we can understand on what we are still missing. Thank you. Thank you to the three of you. I would like to go to a second round and also establishing a wider question on what are the challenges, because there are challenges for providing services in justice, but also an obstacle for innovation. So I would like us to think about the obstacles for innovation and the nature of these obstacles. Are they economic, cultural, political? So I would like you to tell me what you think are the main obstacles for innovation and how you think they can be tackled. So we can continue with the same order. We can start with Marco. Very well. In terms of obstacles, I think that in Nora and Maria Fernanda's presentations, we have identified several of them. We can see the lack of proactivity that we have had, not from this time, but from a very long time in the judiciary when incorporating technologies. And unfortunately, we still have a vision of these judicial processes, procedures that is very based on bureaucracy. So I think that most of the obstacles are related to the difficulties of the judicial institutions to provide innovations for the justice area. But I would also like to focus on other type of obstacles. Obstacles related to the compliance of rights and guarantees in the context of the judicial procedures. I think that we need to focus on how we make sure that even though telematic justice and digital justice can be used in the context of a judicial procedure, we must see how these affect specific problems. And currently, we are seeing in those countries that have been doing telematic hearings, we have seen problems related to the right of defense, the right to having free judicial support, and also that the accused may have a proper meeting before the telematic hearing. And there are great difficulties that are being established. And for me, those should be some of the obstacles that we need to discuss. And other obstacles are more related to technical aspects. For example, the right to contradiction of the evidence and the fact that there are proper techniques and the creation of the cross-reference to the experts. And this is something that requires high quality in the process. And when we cannot guarantee this through telematic ways, this should be as a warning. This type of litigation tools, or also when they can be avoided through different traps, such as the reading of documents, or for instance, the possibility of sharing the information to the witness that is about to declare. Other obstacles are related to what my colleagues mentioned, the difficulty that the judicial authorities have to extract valuable information from the hearing. We break this immediacy principle if we do not have, in most of the cases, with the possibility of being there in person, and not only in the logic of human rights or the rights of the accused, but also access to justice and people in general, as well as the victims in the criminal procedures specifically. I think that we need to identify their different obstacles, digital gaps, and also those mechanisms that are not from the judicial area. We have seen that one of the responses of the judiciary was to close the courts because of the pandemic. And what can we say about other non-judicial services, such as the conflict resolution mechanisms, the judicial guidance and support? This is something that was already proved that in many countries was suspended for a really long time. So I think that there are large amounts of obstacles, and these should lead us to do some reflections on how telematic justice or justice through digital instruments is legitimate. But we also need to ask how we identify the judicial system as a public service that in a certain way can guarantee an essential and proper functioning. If they are minimum conditions that need to be in the constitutional rights with specific areas of emergency, such as criminal law or family areas, that in different states of exemptions, there should be a minimum of this public service of justice, and we should not leave people without these services. And this is another question to close my intervention. Thank you very much, Marco. I will give the floor to Maria Fernanda with the same question. Well, basically, I believe that the great obstacle that existed and that we always have in the judiciary is the resistance that the judiciary has to change. I agree completely with Marco that we need to define where we can discuss this negative to digitalization. And I think that it's totally related to the digital part and the possibility of cooperation with the electronic procedures, with the request of mutual judicial areas and the validity of the evidence that was received through electronic means, with the easiness that we have with these different procedures. I mean, places where we don't have any noises in order to work more efficiently with technology. Now, from where I am talking today, which is a work group that is trying to promote the possibility of access to effective justice for people, we have always thought, what interesting possibility has the construction of innovation and the technology tools if we think of them from justice that is focused on people. So if we put innovation and these tools with this focus in the center, this means that when we need to talk about consultation systems from the users of the system and we need to apply very valuable and digital tools, we need to ask ourselves, can people try this? Is this accessible for the whole community? And the way we are formulating this technology and these innovations is going to allow people to access justice. We need to know that not everyone can use in an efficient way a computer, that there are knowledge gaps, and there are also obstacles with connectivity. And the second principle, I think, is to focus on the reality of the people and their experiences. There are tools that can be sensitive to conflicts in the approach that they are using, that may promote or reduce the scale of conflict. And these ideas need to be in our heads when we are going to apply technology for the service of people. Without a question, we need to improve access to justice. And in this regard, the question that sometimes I ask myself is, if I make the processes the way they exist now digital, considering that we have 5.1 billion people that are excluded from justice, I don't know if I'm making the correct thing. Maybe we can include digitalization and the use of artificial intelligence or advanced technologies as a qualitative opportunity, not only as a technology tool to improve this access to justice and the way in which these justice systems are useful for people. The fourth point, and I think it's important to consider it, is that we need a justice that works in a comprehensive way, that coordinates its work with different actors in this great ecosystem, which is the justice ecosystem. And we can use very valuable tools that can support this collaboration. Let's think about domestic violence, where we need subsidies. Not only the judicial activities lie on what the judiciary can do, but it also requires joint activities with the executive branches and all of the services given by the country. So one of the great challenges is to create standardized solutions, but also solutions that allow to produce singularity. So if we do these forums for people to ask questions, or ask what happens if they cannot use one option because none of them fit their problem, because sometimes they cannot understand the legal extent that they need to face. So all of these matters, I believe, are very important. How do we do for technology to give us data to learn and to improve whether it is the criminal studies, or to do a qualitative leap that allows us to provide services that are focused on people and that make access to justice possible and a material reality, that we need to leave this speech of the rights and the right to have access to this for people. And I think that it is essential to start working with this technology, this concept of prevention justice, by learning from the problems that we face in individual cases. For instance, these bottlenecks when we do the analysis, when we are creating laws. So I think that one of the great challenges that we have in the usage of digitalization is to provide a better justice system. And the pandemic has forced us to innovate at a speed that we didn't think before. And I think that we have a great opportunity to make a difference. Thank you very much, Maria Fernanda. And finally, Nora, the floor is yours. Thank you very much. This panel was very stimulating, and I would like to say that in the previous comments we have shared, and our agency is a development agency, and our target population are people that are within social and economic needs, and in this case, the access to justice that is focused on people. In this framework of the development agenda, I would say that this is essential. So I share the greatest part of the comments, especially from Maria Fernanda. So I would like to say, in the first place, I think that the one obstacle is education. One of the obstacles is knowledge. Current digital technologies have moved the line that some people have, the people that are in the age of 45 years. And there is knowledge from the authorities of the justice institutions regarding the functionalities and the limitations of the digital tools. I think that it's clear that digitalization is here and it will stay here. We are not going back. This is one of the main conclusions that we have reached and that we can make without a question, that all the procedures and all the things that can be done in a digital way in the judicial procedures, they are going to continue to be like that. So one of the obstacles is the knowledge of the limitations that the tools have, as well as the potential, because in order to have a consensus in the authorities of the judiciary, we need to have a minimum knowledge in that regard. In second place, I think that the economic issue is not a great obstacle. This is one of the topics that we had, that I mentioned in the previous participation. I think that the economic part is a myth, at least to consider that what can be done digitally should be done. I do think that the challenge that we need to overcome, as Maria Fernanda and Marco mentioned, when talking about the warranties of the exercise of rights and to guarantee immediacy, that as far as I understand, it will not be removed. And I think that there are going to be exemptions to this digital part. And at least in this first stage, they are going to be more related to the processes of hearings, especially in criminal procedures.
If you ask me about this, I would say that the education topic, well, digital gap is also a gap that we have to take into account. And from this perspective, I think that there have been progress, that there are technologies that allow for their use without being connected. There are technologies that allow disabled people to communicate through an app, which are free for people. And I think that in this sense, some of the access obstacles can be solved by current technologies. And well, I don't want to use more time, but I think it would be important in terms of hurdles. I think interinstitutional coordination is still one, not just in terms of technological interoperability, as Marco was saying, but also the interinstitutional coordination, which is effective in criminal affairs. It is something that we see more, and we know that the enforcement, the prosecutor officers, the courts coordination is pivotal. And I think that this remains an obstacle, and we hope that little by little we will be able to solve this. I will stop here. Thank you very much. Now, we have just a couple of minutes more for questions. I have many, but I'm going to summarize them. I will ask you to provide us with a short answer and to answer just to one question of the several that I'm going to be mentioning. In Mexico and in several countries of the region, there is a systemic structural impunity, how technology can help overcome that impunity. A second question here is, innovation, the technological innovation process must have leadership. It has to assume that leadership in innovation. If we have said that public powers are reluctant. And the third question concerns the experience of Latin America in the procedural reform processes in Latin America and what we can learn from those reform experiences for this new stage, for which reforms are going to be focused on the use of technological mechanisms. So in the same order, please, just one question, and we will start with Marco just for a couple of minutes more. Very well, thank you very much. Let's see. I'm going to answer the first question, which concerns a systemic problem. Previous topic, as Ursula was saying, is manifested very intensely in Mexico, and that's the topic of impunity, and it affects other countries of the region as well. The difficulty of agencies responsible for criminal prosecution to obtain good results, of prosecution policies, investigation above all of complex crimes related to organized crime, corruption, drug trafficking. And because of the complexity and the interests at stake, oftentimes we do not obtain good results. And I think here that debates related to technology could generate a positive result. And we see that those prosecutor offices that are not yielding any results in this type of crimes are highly bureaucratized offices in which the investigation work is a rather ritual work, bureaucratic work, in which abstract investigation orders are given, and for which there is no coordinated work with the enforcement forces. I think that if we had some kind of online system for which the investigation work could be conducted in a more interactive way, and in which we could access online the different pieces of evidence, and for which a more horizontal dialogue between prosecutors and the police is created, and also those institutions with the judicial powers. I think we could take some steps against impunity. So this is the perspective I'm going to keep, a positive one. Now, a couple of minutes for Maria Fernanda. I was going to answer the same question as Marco, but well, he took the lead. I think technology offers above all in terms of judicial cooperation and the filing of evidence, a huge amount of information and unsurmountable levels, so we can tackle very complex crimes related to money laundering and international organized crime. I'm going to answer then the second question, which concerns the leadership in innovation. The judiciary, in spite of its being reluctant, must be a protagonist, because you cannot promote nor impose anything in the judiciary if the judiciary is not responsible thereof. And again, the pandemic and all of its negative effects caused raised awareness and progress that could not be justified backwards, and this concerns the case management. And of course, we need further debate with the judiciary in terms of human rights, this balance between efficiency and human rights, that allows for regularity and to make a case in which the justice will vary in the possibilities of its use. Thank you very much, Maria Fernanda. Well, now for Nora, the third question, which are the lessons from Latin America in terms of reform processes for the future? Very well. Actually, we think that most of the successful experiences are related not just to one single measure or one single variable, but the converging of several, and the first of which is leadership, as Maria Fernanda was saying, at the institutional level, but then a leadership by magistrates, prosecutors, a leadership a little bit different from the traditional one without losing the traditional hierarchy. And to be rather horizontal, we have to think that the prosecutor, the court are a team. And in here, the prosecutor officers are a tool allowing for this leveling up or for this more cooperative work. What we see is that progress in matters of technology implementation always have a leadership by the judicial authority and the desire to have innovation, of course, the technological tools. And this has allowed for the introduction in courts to take one step from digital technology to open justice. What are those key tools? The use of a clear language, the use of media, and surprisingly, we know that this openness in the reform processes has allowed us, this has been the case of court number 10, that people who aren't part of these criminal proceedings decide to take part in hearings in a voluntary manner. And thanks to the publicity, the anticipated publicity of the hearing dates, to clear language, and to the digitalization, which is at the disposal of the data, the statistical data of the court. And this is something very satisfying to know that those implementing reforms are including data sets which are gender sensitive. That's why I say that it's not just a variable accounting for those experiences that we may want to highlight. First, they provide a justice service in an efficient and effective way, but also within the framework of innovation. So I just wanted to share with you this short remarks. I think that we don't have time to do something longer. So thank you on behalf of the organization I represent for this discussion space. Well, thank you, Nora, Marco, Maria, Fernanda. Definitely the pandemic has shaken things for justice, and it has fostered our need to innovate. I will retain the main ideas that this innovation has obstacles, of course, but these aren't unsurmountable. It needs leadership, and it has to be person-focused. We must not just think in terms of efficacy, but also in code of human rights and in the code of the access of the most vulnerable populations. We could continue discussing about this topic for hours, but we have run out of time. Thank you very much for having been with us today. I hope that we will be able to continue these discussions in other spaces. Thank you very much, everyone. Thank you and goodbye. It was a pleasure.
Muy bien, pues en este panel, excelentemente conducido por Úrsula Indacuchea, con la participación de Marco Fandiño, María Fernanda Rodríguez y Nora Lucy, abordamos el estado de la justicia penal derivado de la pandemia y las proyecciones para un escenario post-COVID-19. Muchas gracias a nuestros panelistas. Les recordamos y les invitamos a interactuar, a que escriban sus preguntas, sus comentarios sobre el foro, sobre los paneles, sobre los temas, a través del sitio de internet oficial innovacionenlajusticia.mexicoevalúa.org y a través de las redes oficiales del evento. En Facebook México Evalúa, en Twitter @mexevalúa, en Instagram y en YouTube. A continuación, tendremos el panel denominado Justicia Predictiva, el uso de Big Data. Este panel estará moderado por Vladimir Cortés, oficial del Programa de Derechos Digitales de Artículo 19. Y participará Daniela Andrea Suárez Naranjo, directora ejecutiva de la Fundación Ideas Disruptivas de Colombia. Juan Corbalán, director del Laboratorio de Innovación e Inteligencia Artificial de la Facultad de Derecho de la Universidad de Buenos Aires en Argentina. Y Fausto Santos de Moraes, abogado y docente en Brasil, quienes reflexionarán sobre las buenas prácticas en materia de justicia que usan Big Data y justicia predictiva, sobre la regulación en el uso del Big Data y las ventajas y amenazas de la justicia predictiva basada en Big Data. Bienvenidos a
Big Data-based criminal justice. Good morning, everyone. I was listening to the English interpretation. It's a pleasure for me to be with you. I am Vladimir Cortés. I am the responsible of digital rights of Article 19 for Mexico and Central America. Thank you to Mexico for the invitation to moderate this table called Predictive Justice, the use of big data. And I would like to congratulate as well to organize together with the Howman Foundation such necessary spaces to analyze the role of justice and law faced to emerging technologies. I am also honored to share this dialogue and reflection space with such distinguished guests, with Daniela, Juan, and Fausto. This panel dynamic will be as follows. We will have 2 rounds of participations. Therefore, each speaker will have about 8 minutes for the first block and 8 as well for the second block. Then we will remind everyone who is following this streaming that you can make your questions and that you can share hashtags Innovando la Justicia or in English, Justice Innovation. This is the digital era and the legal disruptive era. We are in a historical milestone in a transit time, as Dr. Marisa was saying, as it was the case in the Middle Ages when they moved to modernity. Then we are placed at the center of the technical innovations that transform society and the image that the human being has of themselves. We have it, the era digitalis, a land in which we don't have a legal and geographical limits of the nation states, and then we have new opportunities open by Robert Schwab. We have to be aware of the fact that, and I'm going to quote, the pact with a machine is not a one-way street. This goes around life and it reduces our life to a streamlined existence. We adapt to machines, and then we have the risk of to forget what makes us human beings. Machines are cold and they do not understand about the truth, beauty, love, or dreams. In the end, the response of who is programming who will depend on whether we remain truthful to ourselves and we do not forget our human essence. And if we are capable to acknowledge in this, all of the beauty that an algorithm will never be able to capture. We are in a moment, therefore, in which the law must not just regulate the new, but as Dr. Barona was saying, to avoid that the last conquests by law are diluted in this digital world. So in this world of software and digital tools, we have to use this. And in this space, the algorithmization of logics, in which we have a new way to conceive the world, justice, law, and its modus operandi. The incorporation of artificial intelligence in justice has a gamut of options, and in here with the panelists, we are going to be depending on this, the creation of predictability models to determine projections for clients, the Pretoria Court of Columbia to improve the selection of protection actions, the judicial argumentation models, and as well as the conciliation, arbitration, judicial reports, agreement, negotiation mechanisms. In this model, we will have the opportunity to explore these and other cases hand in hand with the experts. Therefore, these are incorporated in the justice, and then this can be seen essentially in prevention. It's here where we see the eruption of predictive justice and the criminal investigation, as it was seen in another of the panels. In the judicial decision-making and sentencing, judicial with algorithms has questions of what they are, how they work, who is behind them. Algorithms are new. As Alvaro Pereira Gonzalez said, the actual risk of changing human risk in mechanical justice. If we think about algorithms as cooking recipes and some kind of ingredients, in this case, we will have data, big data, and through a series of instructions, we are going to obtain some results. Those results, Dr. Barona in justice first has some unquestionable effects. We're going to examine these reflections and many more. So I would like to start this first round with 2 questions. What do you think are the best practices in justice affairs using big data and predictive justice? And the second question is, how can we regulate the use of big data for real predictive justice, and also one that protects and minimizes any potential risks that it can entail? First of all, I would like to give the floor to Fausto, who has 8 minutes now to share with us his reflection around these 2 points. The floor is yours.
Thank you for this presentation, Professor Vladimir. I am grateful to be here and join in all these important colleagues to speak about this topic of predictive justice and how we should reckon about this topic. I will try to answer these 2 questions you raised, and then I thought we should start talking a little bit about the Brazilian context, and then I bring now how Brazilian system is working with an artificial intelligence program. We have in Brazil the artificial intelligence program Victor in our Brazilian Supreme Court. Since 2018, Brazilian Supreme Court has been developing an artificial intelligence named Victor. The program is in charge of identifying, selecting, and classifying appeals to a certain set of issues. Such set is compounded by formal decisions which have collective binding. This procedure of picking and classifying is called broad repercussion. In 2004, this legal institute was created, improved by the private procedure code in 2015, and it has been working as a kind of precedent with the following characteristics ever since. First, the Brazilian Supreme Court recognizes one legal issue as a broad repercussion when the court had received many cases raising the same legal claim, and this could affect the Brazilian state socially or economically. Second, equal cases must be put together in the same legal group. Third, the court selects some petitions to be analyzed as a representative of the claim. Fourth, the Brazilian taken in these representative cases bend all the others. Fifth, the Brazilian Supreme Court builds a ratio decidendi through a legal proposition called thesis. Up to now, there have been around 1,080 theses. Finally, the thesis must hold all the cases with the same claim. Turn to the Brazilian Supreme Court routine. The court receives about 400 appeals daily. All of them are digitalized and make part of the electronic process. Many of these appeals are identified as a matter of broader repercussion. Curiously, the Brazil legal system has more than 80 million active lawsuits. In this procedure, one Brazilian Supreme Court clerk in charge of identifying, selecting, and classifying appeals takes up to 30 minutes to finish this process, with 75% of accuracy. The artificial intelligence program created can do the same task in 3 to 4 seconds, reaching an accuracy rate of 91%. Here, I must highlight the program runs operating just with the largest legal issues volume previously chosen. To estimate, there are about 28 of such legal issues. I will skip what I call here technical aspects, and I will assume that it is possible technically to have this legal classification about we have a legal premise and classify automatically, technically with artificial intelligence, some lawsuits. I will bring for us 3 aspects to discuss this classification trend. The first aspect is the regulatory aspect. The issue here is whether the following 2 points are in accordance with the Brazilian legal system. First, is it legally possible to decide a group of equal cases using the same decision as the main normative premise? Second, is there a legal prohibition for using technology to support or replace human decision? The Brazilian Constitution was amended in 2004 to admit broad repercussion as pointed before. In 2015, the Private Procedure Code was changed to create a new way to hold legal decisions. By the Private Procedure Code, the Judiciary must gather legal cases in a group and make just one decision binding all the cases. This should make procedure faster and more efficient. Consequently, there is legal ground to have just one decision for a group of cases. About the second point, despite of being possible to have a technological process to identify, select, and classify cases automatically, to one thesis of broad repercussion, what can be called as legal classification. The National Bureau of Justice enacted in 2020 the Regulation 332. Under this regulation, programs must not automatically perform legal classification, but just suggest this result to a judge. In fact, only judges must be responsible for the legal classification activity. The Brazilian Supreme Court program is understood in this sense as a supportive tool. Even though the regulatory definition seen above, one problem may arise when artificial intelligence is used to model legal reasoning and to create a premise for legal classification. This will be faced in the theoretical aspect. For this, the premise for legal classification is a content of legal thesis in broad repercussion that demands a translation of legal knowledge into computational programming. This translation may face the problem of hypernormatization. The hypernormatization may happen when factual or normative features which grounds a legal premise by artificial program uses do not adequately formalize the thesis. From this phenomenon, programs may not run based on a real pattern embedded in legal knowledge, but an artificial pattern that overfits factual and normative features.
De las características normativas y factuales como norma decidendi. Ahora, aquí el patrón está muy representado y se tiene que asumir de manera progresiva como un conocimiento jurídico incuestionable con base en la teoría básica del precedente. Es posible establecer que un patrón jurídico ignora dos mecanismos de actualización del conocimiento jurídico como la distinción y la anulación. Aquí terminan los dos aspectos y más adelante voy a hablar con ustedes sobre el aspecto filosófico.
Muchas gracias, Fausto. Desde luego, creo que se comienzan ya a dibujar estos dos elementos, sobre todo en la parte también regulatoria y los ajustes que se tienen que hacer de cómo interviene la inteligencia artificial en los procesos de justicia, ¿no? Como una herramienta de apoyo.
As a supportive tool. And now I would like to give the floor as well to Daniela to speak about the same two points. And right now we will have 8 minutes. So we can adjust for the next block. We will only have 5 minutes. The floor is yours, Neil. Thank you very much, Vladimir. In terms of good practices in Colombia, we had the opportunity to design the disruptive strategy against drug trafficking. And this has been a strategy that in terms of execution has left us many experiences and learned lessons because it goes to the practical aspect of things and not just a technical, conceptual, or philosophical aspect of things of big data. What did we understand from our strategy, and that's why we called it disruptive, is that we had to break up with a classical approach, and we had to work with justice administrators, and not just in terms of looking for the responsible actors and go into the investigation, collection, sentencing, and also how we can stop criminal learning, which allows for criminals to survive and to have a high impunity rate in our countries as well. Then we have this strategy with projects that from applied science, are going to destabilize the criminal networks, specifically in terms of drug trafficking. You already know Colombia has a big problem, historic problem, related to the production of chlorohydrate of cocaine or synthesis drugs which are not produced in our countries, or the cocaine chlorohydrate. And in specific terms of the big data analysis, we created an algorithm that allowed to identify the placement of big labs producing this product. And in perspective terms, if we intervene at one of these labs, what was the likelihood of another lab to be mounted again in a nearby area that in judicial terms we thought to have cleaned. And why is this important? Well, we have specific examples because in terms of transparency, when we conduct analysis based on data, well, we know that institutions, we will have very important registrations of people who are part of our institutions go into the information. Well, entering information by mistake, some have differentiated criteria that we have to standardize, and we have a high black figure. And this is because our institutions, at least in Colombia, and I know some international experience, they have some operational goals in terms of strategic management that make officials sometimes to modify these figures. So then our intervention will not have an actual impact on the final phenomenon. We have to be very careful here, and we have to be very transparent here. This information that we're going to be having must have as well validation in the field and an intervention with the key actors that allow us to have a triangulation, so we can have an appropriate coordination with the high strategic elements which are here something really important. It's not just the need to create algorithms, because it's going to take us to a space in which we are all working in terms of cyber defense and cyber security, but also we have to understand that the creation of those algorithms and the application of the science has to be directed to some very clear objectives in a judicial and operational terms, together with the army and the enforcement. We have to be able to define in a standardized way those goals, and we have established three main goals: a structural goal that allows us to understand the organization of those criminal networks, who are the ones operating and dynamizing them, and knowing that these organizations are used as a criminal outsourcing and not just as a highly identifiable heads, as we were saying before. And second criterion, corruption. People who are public civil servants, and they create both legislation and judicial advantages and economic advantages for criminal organizations. And the third element, which is also very important, is the economic financial criterion, how the goods created by those illegal economics, in our case, not drug trafficking, end up completing a cycle to get to lawfulness. And which are those institutions that allow for these assets to be laundered and to go back to fed those criminal organizations? In such terms, our experience is the disruptive strategy against drug trafficking, and with the use of that information being very clear how we can contrast this in the field, also including the topic of counterintelligence. So we can clean the level of corruption that we can have within our institutions, and we managed to conduct a very effective intervention, just not just in terms of laboratories and cocaine chlorohydrate, but also in terms of bioengineering, modifying this plant so it does not produce this alkaloid, changing the petrol and so we have to think about science and beyond the algorithm, and which are important and which classically have been instrumentalized so we can fight against organized crime. And an algorithm we created for laboratories. It's not that this was just it was not just some historical statistics for the concentration of heat, which and then we had to intervene in labs. What we did was to adopt a British technology, which is used for the identification of serial killers. And according to some variables such as closeness to hydrological sources, input providers, and the presence of illegal armed groups, so we created that algorithm, predictive algorithm, to know whether in a moment we could intervene a lab, what the likelihood for this to be rebuilt, and in which this will happen. In Colombia, we have a seasonality of 2 days, and we have tried this in the field when a laboratory is dismantled into 2 days. Criminals already mounting another one, and for this we have to be more efficient as a state, but we draw on such tools. Finally, for the second question, which was the topic of how to regulate this in our country, it's Daniela. I'm sorry, I'm going to interrupt you here. Maybe we can leave this part for the second.
I'm going to interrupt you. We are going to leave that part for the second block. And okay, I believe we are saying how we are using this from the district's attorney office. And now we are going to give the floor to Juan for him to make his comment in 8 minutes about these good practices and what are the elements in order to start. Thank you very much, Vladimir and our colleagues. It is a great pleasure to be here with Daniela and Fausto. I will try to summarize in this 7 minutes and 46 seconds 3 aspects related to this question that you asked, Vladimir, and to Fausto and Daniela's question. First of all, and this is out of the experience of creating the cases Pretoria, Prometea, and another one that is going to be called Tucuy Ricuy in the Constitutional Court of Peru, which is about to be launched in 15 days, which is a prediction system for gender violence. And this is our 6th prediction system. And I'm going to try to talk from this place by having incubated 6 different predictive for 6 different issues. The first thing that I wanted to mention, because I think that this is related to the lessons learned, I think that it's very important to do a differentiation between small data and big data. For me, that is critical. One thing is to predict in small data and another thing to predict in big data. The second thing that I wanted to share with you is that to predict this forecast or different predictions imply to reduce uncertainty and manage uncertainty, because what an algorithm does is not to tell us the past, is an interpretation, an algorithm interpretation of the data from something from the past, and always the past is something that we cut out. And this is important to highlight because it seems that predictions are something like a diagnosis that we should follow, when actually, since they have certainty rates, they are usually previsions that are subject to different assessments before using that prediction. That is my first idea, because this is the step before regulation. Because if we know that the past that we're trying to predict is something that may have different nuances, it's not what we call the data set. It's the logic of interpreting this data, and it is clear that prediction is going to be a consequence of this other thing that we need to assess. And if it's not assessed or diagnosed by the officer that is going to use the algorithm, there is a robust bias from the competency standpoint. When we have tried, may I please share screen because I cannot do it? When we have tried to do predictions with big data, we have seen that in Latin America, it's very difficult to find big data scenarios. In cybercrime, we may have big data things, as Daniela was mentioning, but regarding civil law, labor law, or commercial law in general, it's very difficult to get 5 million of something or 10 million of something. Usually what we get are thousands of data in the best case scenario. 10,000 or 20,000 maybe, because let's remember that when we are trying to predict, we detect certain segments that we can forecast, and we are not predicting in general what a court will rule. This is only something that someone that has not tried to predict a lot would say. So we need to find segments so that this algorithm may adjust faster and have a more efficient yield in the first stage when we are trying to train it. Now, I think I can share screen now. What I wanted to share with you is that when we are trying to train an algorithm, in 2017, we realized that if I put the case number and we got it with 5,000 rulings, we trained it with 5,000 rulings such as topic model, regression, and different topics that are machine learning and not big learning, we could achieve a high predictive yield, the 93% in percentage. We didn't have to apply a neural network. This is a technical issue. Well, in 2017, we found this with Prometea. So we put the case number, and the system creates the case directly. So what it does is ask if I want to do a self-sufficiency control. In numbers, according to the Inter-American Bank, who did an audit to us, we had an audit in Prometea. They were there for 2 days, and we gave the Inter-American Bank the 8 data sets that we had for this source code. Then after that, the IDB had these numbers as they are published here. You can see it here. I don't want to overwhelm you with all these numbers. But in the Pretoria case, which was a similar approach, we found 2,500 rulings in health cases, and with 7 data sets, we had the rates on 91%. And the logic was of 202 workdays to 36 minutes. And we reduced the times from 202 days to 36 minutes. So this is the constitutional organization that receives the largest amount of cases in Latin America. They receive 1 million cases a year. These are numbers that not even Brazil overcomes in terms of courts. This is 1 million cases a year, and this is something that I had not seen before. The last thing that I wanted to share with you is that when we reason this prediction phenomenon, there are different ways of executing it. So I'm going to show you another way that we found recently, which is that we can upload a PDF file. This is another prediction that we did for the IDB for the review processes of individual contracts. This is a process that is also from an audit. And we upload a PDF file. This is another way of doing this algorithm. Instead of sending the system to go look for it, then I upload a PDF file. And when I do it, what the system does is create a report from reading the PDF. So it creates a report that I can download in a Word file. I could share it with you, but I don't want to go beyond my time. This is what I will say to finish up. What did we find in the small data that didn't happen in the big data? Greater rates of having correct answers, and also that with fewer amounts of data, we had a better performance. So my advice is that by default, we need to predict with small data, and when we cannot do it with that and with machine learning, not deep learning, then we can go to big data. We need to go the other way around than what is being done in the corporate world. In the corporate world, we start with big data and deep learning, but I would suggest that justice should begin with the classic machine learning with small data, and if we cannot do it, then deep learning. Thank you. Amazing, Juan. Thank you very much. I think that the last thing you mentioned and the title of this panel starts with this predictive justice and big data, but we are also on the need to rethink this approach. And there is also an element that you mentioned, the audits, how important it is when we are addressing this active part of the regulations, and how necessary are these, or how important are these to identify the scope and the rates that we see. As you mentioned, 91%, and they can vary. In some cases, we can have 83%. But what you have identified as well is that these are high rates, and I think that in audits, this is also an element that needs to be taken into account. Now, we are going to start with the second block of participation, where you can also see a predictive justice on the one hand, and on the other hand, we can see this application of big data statistics prediction in the law world, something that we have called artificial legal intelligence and jurymetrics. And this is something that may be translated from judicial language or symbolic language, starting with mathematics and logics. This is the judicial statistics in order to predict, as Juan was saying, in order to reduce uncertainty and to have segments of the different analyses that are done. And also, as Juan mentioned from these cases of Pretoria and Prometeo, in the case of Colombia, we have also seen throughout time how this has been done in order to predict the results of the rulings. For instance, in the case of the European Court for Human Rights, where they have this percentage that's around 79%, or another court that has rates on 83%. We have also been incorporating new elements, which is also related to what Daniela mentioned, with the different tools of criminology, theory, mathematics, and the different statistics for the analysis of criminal phenomena. And another thing that I would like you to address, I think that in this first block, we analyzed, and you also analyzed it very deeply, the regulatory aspects and also how some of the advantages and the good practices that this has represented in the case of Argentina, Colombia, and other countries, for instance, Brazil. I would like you to focus on what are not only the advantages that predictive justice that is based on big data or on small data are, but also the risks and the main threats in terms of human rights, privacy, bias, that can also come up, and maybe link that to what are the needs in order to solve this. There is this idea that there is a reduction of times. As Juan was saying, it comes from 202 days to 36 minutes. So how these processes are being done. And as Fausto mentioned, this is a support tool, but I would also like us to identify what things we should take into account from the standpoint of discrimination, privacy, and other aspects that can be used also with artificial intelligence and all of this, and all the things that we have called the algorithmization of justice. I would like to start with Juan, then maybe Fausto, and then Daniela, please. Well, Vladimir, I am going to try and focus on specific things that we have done in the practical part, and there are a lot of theories from other countries where they have different realities to ours. For instance, we cannot follow the justice in Estonia because they have a completely different scenario to our countries. So I'm going to do an 8-point synthesis, very briefly. First of all, what we call intelligent by design is before you predict something, you need to understand in a comprehensive manner this process and do a re-engineering so that the predictive opportunity complements the opportunities of automation. So there is not a single prediction. There can be a list of predictions that can go in different segments of the process, and not necessarily is a robot or an algorithm that decides. This is very based on technology, and it's almost reaching science fiction. It's more practical. It's tell me specifically in this process of gender violence, in this process of different damages, what things we can predict and what things are feasible to predict regarding the data that you have. The second thing is, if we know that data are a picture of reality that I'm going to take as an input for prediction, then I need to have a team for data governance that should be in charge of doing what data scientists call to normalize the database, to reduce representativity bias. And I could do a list in this stage that we call the data governance stage. These are the stages that we are focusing on. The third is, once we did a smart approach by design, we have separated the tasks and we have divided the automation possibilities. Starting there, we can do a diagnosis of what could be the algorithms, what we call the algorithm design, because precisely there are algorithms that can be more traceable and others that don't. So we do a risk assessment. This means that if we are going to use optimization algorithms that are based on neuron networks, the box becomes completely black. I cannot explain specifically why, but let's imagine that I use 8 optimization algorithms. At the same time, I have a neuron network that is being trained. These are a lot of black boxes that are acting together, and these are like having pizzas that are being cooked by someone that we don't even know who developed that. So the way of explaining this is so far and so difficult that I would advise that this is not the beginning of the road, because if this is the beginning of the road, we need to use this in something that doesn't have such an impact in human rights, because otherwise we are going to have a problem with the algorithm, such as what is happening with facial recognition. So this is such a black box because of different reasons, because it goes beyond constitutionality. And the last thing is, well, I'm running out of time, but the last thing is to do a lot of testing with a lot of data sets in training. In the international community, we have a formula which is 70-30, which is to leave those data sets to train the algorithm and always do a mitigation when the system, in the exit of the system, before entering the testing phase of the system. Thank you very much. I don't want to go beyond my time. Thank you very much, Juan. I think that you mentioned in a very good way what are the aspects and the elements in order to mitigate this from design. And also what I think is very important on data governance. Just to mention, we have an additional minute, so you can also take an extra minute for this second block. And Daniela, who also had some pending topics in the first block, please go ahead. Thank you very much. I thought that we had our colleague from Brazil talking now, but I will take advantage of this opportunity to start the second answer with an example from us, which is that the brands of cocaine, hydrochloride, and these tablets of cocaine have an image. And in Colombia, we have a record of these images for more than 20 years. And we wanted to create an algorithm for this in order to create an alert system to see what brand was belonging to what crime organization. And we found a problem because we had a great amount of information. And imagine how many drug factories we may have in our country. And some of them were registered as cocaine and some others from cocaine hydrochloride. So from the registration of the information, there were mistakes, and the pictures were not taken in the proper way in order to apply the algorithm. So this is related to what I mentioned in the previous intervention, which is the importance of entering the information, to have technical requirements in order to clean it and make it easier to work with later. Not only that, the fact that we have this data in terms of transparency are just the ones that are there, but we need to have a good regulation to support it. In the second place, in our country, there are some regulations that classify information in different categories, such as reserved or top secret, according to the trend or the topic. And for us, it is very important to know who are going to have access to that information. It is a problem when private entities or private companies are the ones doing the exercise for public institutions, because we have some boundaries in order to give the information. And sometimes this creates a problem in order to generate these dynamics that lead us to an effective result without violating fundamental rights, especially with the experience of implementing different figures in order to find specific data for cybercrimes. And we need to know what are the boundaries for these agents when they are collecting this information, and what are the institutions that may have access to this official information from us. And this is within the framework of these constitutional laws that we know we still have a long way to go in order to establish them. And we cannot only be based on the Budapest Convention in order to regulate the digital area and the cyberspace. And something to finish off is proportionality and the rationality of the use of this information. We need to be very aware of the consequences that it may have, not only in technical aspects, but also in the life of people, in order to do this analysis without having a verification in the tangible space or in the qualitative part. Thank you. Thank you very much, Daniela. I think that you also addressed very good elements. One that is doing a reference to how we can incorporate and how we can work from small data, but we can also see how we work, at least from the case of Colombia, with large volumes of data, and definitely the requirements on how this data is being collected and how these data sets are being created. We need to have clean data, and clean data is something that always helps a lot. And of course, something that you point out that I think is very important is how to create a regulation so that the activities that are being performed, such as having different agents working in that, and to create a wide protection regarding human rights and also regarding privacy. And also the proportionality and rationality and the consequences that they may have. And we need to be aware of those consequences. So I think that this is very related to some of the principles that Juan enlisted and that are set here. And now we can go with Fausto. Please go ahead as well with these thoughts on the advantages and the threats of predictive justice regarding big data, small data, human rights, privacy, and...
Thank you, Professor Vladimir. After listening Professor Juan, I will quickly reconnect with my technical point. And after this, I will develop some reflections about the philosophical aspect, what I think connect with all your the issues you had pointed before. So about the technical point in Brazilian system, all the appeals are received electronically by using PDF files. This information is relevant considering these files are raw material to build a data set for machine learning. Then the first step is to transform PDF files into text for natural language processing. Interestingly, some PDF cannot be immediately transformed into text because they are compounded by images. In this case, it's necessary to use a technique of optical character recognition to make image available in text. Having the text stored in the data set, natural language processing starts using a combination of support vector machine and XGBoost classifiers to match the appeal documents to some choosing decision of broad repercussion. As informed before, the accuracy rate in this process is around 91%, regarding to just 28 legal theses considered. To clarify, this thesis had already been decided by the court and their normative premise had also been established. Now I will try to present some philosophical aspects connecting with the issues Professor Vladimir brought to us. So from this philosophical aspect, two types of concerns should be considered. One involves epistemology and another ethics. Epistemologically, the concern coins whether human being is necessary to apply the law. The answer is maybe. In equal cases, those characterized as in broad repercussion in Brazil, human beings would not be necessary since artificial intelligence program can match case circumstances to a legal classification premise. This is a matter of epistemic capacity. In spite of being legally prohibited in Brazil, the artificial intelligence program can technically perform an epistemic capacity matching cases to legal classification with a huge percentage of accuracy. Such legal prohibition is based on a dogma, especially considering the following two reasons. First, the legal premise used for enacting a decision is built by human judges. Second, how it has been seen in the technical aspect, the program performs the legal classification much better than humans. On the other hand, the ethical concern brings necessities as responsibility in legal interpretation, transparency, and explicability. Nowadays, artificial intelligence cannot come up with legal premises. Only human beings have an inner responsible capacity to set what law ought to be applied in a particular case. Such responsibility requires an integration between what law is and what law ought to be. In a sense of claim of correctness, to quote Robert Alexie, or integrity and consistency, to quote Ronald Dworkin. About transparency, human beings must be aware when artificial intelligence programs are used in their case, even if the machine is used just for supporting human decisions. Looking at the practice here in Brazil, this is not always the case. In the sense of explicability, courts must adopt in their website an easier explanation about how the programs work and disclose scientific studies reporting technically what the programs really do. This is not frequently available either. I identified these two issues, huge issues we should answer to have the artificial intelligence uses by our judiciary. Thank you, Professor Vladimir.
Gracias a ti, Fausto. Me parece que colocas también dos aspectos cruciales y destacaría tanto la parte...
Very important aspects. in the epistemologic part, and with also these two elements regarding the ethical part, the responsibilities which are related to transparency and explicability. I think that this is not only about the incorporation of it in the justice systems and also in the criminal investigation, but also on how the citizenship approaches and wants to know how this is being applied and the possible impacts that it may have on themselves and their rights. And I also think that it's a very important effort of approaching the complexity that the world and artificial intelligence as well as machine learning implies, not only from the standpoint of engineers and mathematicians, but also when having these elements that are crucial, such as transparency and explicability on how these are being used and how they can have an impact on people. I would like to use these last few minutes for each of you to say in like a tweet in the famous 240 characters, something to close this session, this predictive justice and the use of big data topic. And right now we can also say small data as well. What we see in the region, and also based on what Juan was saying, we cannot bring it and we cannot incorporate the realities that other places are living to what is being done and what is being searched for in the Latin American region and the Caribbean. And this has an innovation component that is also very important and has a series of ethical considerations as well as based on fundamental rights. So it's kind of looking ahead and also focusing on today, on what we are missing in terms of regulations, what things we can see, and what is important to strengthen of what is already being done or what is missing. So we are going to go once again in a random way. We can start with Daniela, then Juan, and we're going to close again with Fausto. Daniela, please go ahead. Perfect. From Colombia and from Latin America, it is necessary to strengthen the governance framework in terms of information security and safety. There are different things that our public policies address to this, but we need to strengthen it, and also the adoption of models and standards to set boundaries for the use of new technologies, because even if we are moving forward with these aspects and we have different frameworks that allow the protection of these fundamental rights as well as the roles of the citizens, which are the ones that are going to be affected by the operability of the implementation of these new technologies. That's my tweet. Very well. Juan, please go ahead. Vladimir, it's my turn? Okay. According to what you were saying, Vladimir, I think I was trying to do something, but I changed it because of what Daniela mentioned. I think that if we look back, we need to be very critical of ourselves. The internet and computers, which were the third industrial revolution, the justice in Latin America took approximately 30 years in each, well, let's say 20 or 30 years to be incorporated. Imagine that these were less intelligent technologies. If we had the situations that we had with these technologies, artificial intelligence is going to need 20 to 30 years to escalate. So our challenge is for it to take at least half of that time. If we achieve that, then it's a really long time. I think that's my message. I don't know if it's full of hope, but I think that it's realistic. Thank you. Thank you, Juan. I think that it complements completely what Daniela mentioned. I think that it is very related to that, to strengthen the standards, the protection models and governance, but also taking into account that the periods of time does not require another 30 years for us to achieve this and for us to solve.
I would like to express two concerns. The first is how the judiciary model legal knowledge or legal reasoning. We couldn't just gather a lot of decisions, a huge volume of decisions, considering this big data trend, and ask the algorithm to create some kind of a proper reasoning. I think we should increase our studies in legal theory to help us to identify the best decisions. We just need to use the best decisions to create this data set, and with this, have this algorithm trend. And my second concern is, what is the real problem? Because in Brazil, we have a huge volume of lawsuits. And the real problem is not uses of artificial intelligence, but how our state is not accomplishing its tasks. So this is my final remark. Thank you.
Pues muchísimas gracias. Creo que
thank you very much. I think that all the comments from Daniela, Juan, and Fausto, I think that this gives us an overview of where Latin America should move forward in predictive justice and how to incorporate the use of artificial intelligence, algorithmization of justice as well, with these elements on the table to identify the real problems, to see where the states have to go to in order to solve the need of innovation without taking a really long time, and also what Daniela mentioned on how to create protection frameworks for fundamental rights and for innovation to not be translated into a damage of what we're trying to solve with the technology, or what these ideas in justice are creating. With no further comments, I would like to thank Daniela, Fausto, and Juan. It has been very enriching to know the work that you are doing in Brazil, Argentina, and Colombia. And I think that this is fundamental. This is necessary as well for the case of Mexico, where we also have very high rates of impunity and delays, and also the absence of regulations, as well as how these can move forward so that the road that we can take has very important results. So with no further comment, please continue in this forum. To all people that are watching us, I think that we don't have any more questions or comments. So this is the end of this session. Once again, I want to thank Mexico Evalúa, Nauman Foundation, Fausto, Juan, and Daniela for your participation in this panel. Thank you very much. And we will stay in touch. Thank you very much. See you soon.
Fabuloso panel sobre la justicia predictiva y el Big Data. Muchas gracias, Vladimir Cortés, Daniela Suárez, Juan Corbalán y Fausto Santos, por compartir este conocimiento y estas perspectivas. Bien, pues llegamos a la primera parte del primer día de este foro. Recordamos que tenemos el hashtag Innovando en la Justicia, para que a través de las redes sociales y a través del sitio oficial del foro nos compartan sus impresiones, sus comentarios, sus preguntas, ¿no? de estos temas. Una recapitulación muy breve de lo que vimos ya en esta primera parte. Tuvimos un panel de inauguración, después hablamos de la inteligencia artificial en los sistemas de justicia penal. Posteriormente hablamos de las innovaciones tecnológicas y sus aplicaciones en la justicia penal a partir de la emergencia sanitaria por COVID-19 y con este último panel sobre justicia predictiva. Haremos un receso, regresaremos a las 16 horas, hora del centro de la ciudad, del centro del país, de México, y continuaremos con dos actividades más, ¿no?, para este primer día. Abordaremos el tema de justicia de género, innovaciones e impunidad. Posteriormente, calidad de la justicia y responsividad de las instituciones. Les invitamos a que continúen conectados y conectadas en la transmisión de este foro e interactuando a través de las redes sociales. Hasta pronto.